The ratification of the Constitution and the Bill of Rights. The ratification of the Constitution required the affirmative vote of special conventions in 9 of the 13 original states. Two groups quickly formed. The group that supported the Constitution came to be called Federalists, and Anti-Federalists were those who opposed the Constitution, usually because they thought it gave the national government too much power that would erode states' authority and endanger individual freedoms. And the proposal for a Bill of Rights became the dominant point of contention in the ratification campaign. The original Constitution, as written in 1787, did not yet contain a Bill of Rights. Mercy Otis Warren, pictured here, became one of the better-known anti-federalists. She was already known as a writer and historian and participant in the debates during the American Revolution. She wrote two pamphlets or essays, A Columbian Patriot and Observations on the New Constitution and on the Federal and State Conventions. And she thought that the Constitution threatened citizens' natural rights. It gave too much power to the national government at the expense of the state governments, and it delegated too much power to the executive branch at the expense of the legislative branch. She also complained that it lacked a Bill of Rights to limit the vague powers delegated to the national government, including Congress's ambiguous power to make all laws deemed necessary and proper to carry out its enumerated duties. Another anti-federalist was named or nicknamed Brutus. Brutus was an anonymous writer who may have been Melancton Smith, pictured on the left, or Robert Yates, pictured on the right. We aren't entirely sure who Brutus was. But Brutus wrote several essays discussing the proposed Constitution, and he thought that the power to tax and the necessary and proper clause gave Congress too much power. He thought the territory of the United States was too large to be ruled democratically. He worried that people wouldn't know their own representatives or what their representatives were up to. He thought the 3/5 clause was offensive. This was the clause that that counted slaves as 3/5 of a person for purposes of deciding the population of states and how many representatives in Congress to award them and in the Electoral College. And Brutus, like many others, thought that this unfairly, unjustly rewarded slave owners with extra power in the government. He also thought a 6-year term for senators was too long. It gave them an opportunity to do things that the voters wouldn't approve of and not be held accountable for years afterwards. He thought the federal judiciary was too powerful, and he thought that a Bill of Rights was necessary to protect individuals and states. These were 3 Federalists, John Jay, James Madison, and Alexander Hamilton, and they wrote a series of essays in support of the Constitution that have come to be called the Federalist or the Federalist Papers. In Federalist number 10, James Madison discussed how to prevent the consolidation of power in one branch of government. He said the only answer that can be given is by so contriving the interior structure of the government as that its several constituent parts may, by their mutual relations, be the means of keeping each other in their proper places. He's describing here what we now think of as a system of checks and balances. So the executive and the judicial and the legislative branches will each keep the others from becoming tyrannical by checking or restraining their powers. Madison went on to write a reflection or a philosophical reflection on government itself. He said it may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and in the next place oblige it to control itself. So the root of the problem is that people are not perfect, and imperfect people need to be controlled by a government so they won't abuse one another. But the government can only be implemented by imperfect people, so the government itself needs to be controlled so that it doesn't become abusive. It is of great importance in a republic not only to guard the society against the oppression of its rulers, but to guard one part of the society against the injustice of the other part. American society, Madison thought, would be so large and contain so many separate descriptions of citizens as will render an unjust combination of a majority of the whole very improbable, if not impracticable. The society itself will be broken into so many parts, interests, and classes of citizens that the rights of individuals or of the minority will be in little danger from interested combinations of the majority. Madison thought, in other words, that the diversity and size of the United States would work to prevent oppression. Whenever one part of society tried to become too powerful and oppressive, other elements of the society would unite together in an alliance against it and keep it from becoming a majority and capable of oppressing the others. Madison thought that the federal system, designed in the Constitution, provided a double security for protection of individual liberty. He said the power surrendered by the people is first divided between two distinct governments, the national and the state, and each government will check or control the other. So he thought that Texas, for example, could fight back if the national government became oppressive, and vice versa. The national government could fight to defend its citizens in Texas if the Texas government became oppressive. He then wrote both levels of government are subdivided among distinct and separate departments that can check each other. And here he's back to the idea of separation of powers and checks and balances. Alexander Hamilton also wrote some very important essays in support of the Constitution. One of them was number 78, and he was describing the role of the courts and how they had an important place in keeping the other branches, the executive and the legislative, within their constitutional authority. So, for example, he said the legislature was designed in the Constitution to have limited authority, not unlimited authority. And the courts were designed, these are his words, to be an intermediate body between the people and the legislature in order, among other things, to keep the latter within the limits assigned to their authority. So if the executive or the legislature, if Congress, exceeds the authority that it's given in the Constitution, the courts must step in and stop it. He wrote, the interpretation of the laws is the proper and peculiar province of the courts. The Constitution would be the fundamental law of the United States, as it represented the intention of the people as to the powers of their government. The courts must ascertain its meaning and the meaning of legislative acts. Whenever there was a conflict between the will of the legislature declared in its statutes and the will of the people declared in the Constitution, courts must prefer the Constitution over the legislature. Hamilton went on to explain why he thought, contrary to the Anti-Federalists, that a Bill of Rights was not necessary and even unwise. First, he thought it was unnecessary because the federal government only had those powers expressly granted to it in the Constitution. In Article 1, Section 8, the Constitution gives Congress a list of enumerated powers, And it does say that they can do other things that are necessary and proper to the carrying out of those enumerated powers, but they are not given a blank check to do anything they want. They can only do something that there is authorized directly or indirectly by the Constitution. So Hamilton asked, why declare that things shall not be done, which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed? So Article 1 gives Congress no authority to regulate the press. It gives Congress no authority to infringe upon the freedom of speech or religion. And since those powers are not given, you don't need a Bill of Rights, Hamilton says, to take that threat away. Worse, if you include in the Bill of Rights a list of prohibitions, like not to infringe upon freedom of speech, freedom of press, freedom of religion, etc., people might get confused and think that Congress can do anything not prohibited in the Bill of Rights, which isn't the proper way to understand the Constitution. Well, the Federalists, like Hamilton and Madison, won the bigger war, the bigger fight. The Constitution was ratified, and it did go into effect. But they had to give in on the question of a Bill of Rights in order to persuade some of the anti-Federalists to support the Constitution. James Madison, in effect, promised them that the very first thing the new Congress would do is add a Bill of Rights. And he kept that promise. He was elected to the House of Representatives. He wrote a series of proposed amendments to the Constitution and argued their way through the House and into passage and eventual ratification. And I want to go over those amendments, the Bill of Rights, briefly, each one, to give you an idea of what's in them. So first, Amendment 1 says, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So there are 5 freedoms protected here: freedom of religion, freedom of speech, freedom of the press, freedom of assembly, and freedom of petition. These were considered crucial freedoms to the preservation of the Republic. Jefferson, for example, wrote, "Our liberty depends upon freedom of the press." They are not absolute freedoms, though. There are limited exceptions. For example, in a 1918 case called Schenck versus United States, the court said free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Amendment 2 says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For many years, there has been a debate over what this amendment means. Does it protect an individual's right to bear arms, or does it protect the state's rights to arm and train militias? And another discussion was, does it apply to the states or just to the federal government? Well, in a case called D.C. versus Heller in 2008, the Supreme Court ruled that individuals may carry firearms for lawful purposes, so it is an individual right. In a later case, a couple of years later, the court said that this right applies to the states as well as the federal government. Amendment 3 says, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So, one of the reasons this amendment was included was that during the Revolutionary era, one of the things that angered the colonists the most was the British quartering of soldiers in the homes of private citizens, of Americans. And doing this in a time when supposedly they were at peace. There was no war going Americans disliked this so much that they wrote it into our Constitution, made it the Third Amendment. Patrick Henry explained, one of our first complaints upon the former government was the quartering of troops upon us. Now, quartering is meant for a soldier to stay in a citizen's house. During the War of 1812 and the Civil War, the U.S. military did quarter troops in private homes. This amendment protects against doing that in peacetime, but during war it's okay. And the Supreme Court has never had to decide a case based on this Third Amendment. Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. This amendment was also a response to a practice that the British engaged in that offended the Americans very much. The British used something called writs of assistance, which were general search warrants that allowed a government official to search anywhere he liked, for whatever he liked, for as long as he liked. He could go into your office or your home, and they used this to search for smuggled goods, but the official didn't have to state where exactly he expected to find something, what exactly he expected to look, what he was looking for, or a particular time to do the search. He could just come and go as he pleased. Americans were outraged by this, so we wrote Amendment 4, which says they have to have probable cause. Probable cause exists when there's suspicion that criminal activity may be taking place. There has to be a warrant. A warrant is issued by a judge, giving the police permission to enter a private home. And the warrant has to be specific. It has to say what exactly is being searched for and where it is expected to be found. Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime, unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So this amendment and several following it protects the rights of people accused of a crime. It guarantees your right to a grand jury for criminal offenses, infamous criminal offenses, it says. A grand jury has to determine if there's enough evidence to accuse someone of a crime before the government can take you before a petty jury and accuse you of committing that crime, put you on trial. It protects your right against double jeopardy. Double jeopardy is when you're tried twice for the same offense. So once you've been declared acquitted, that is, by a jury, you cannot be tried again or over and over again for the same crime. You have the right not to incriminate yourself, not to testify against yourself, that is. You also have the right, and this is maybe the most important, to due process. Before the government can take away your life, liberty, or property, it has to give you due process of law. In other words, some sort of trial or hearing where you can defend yourself. And the government can use eminent domain to take your private property for public use, but only with just compensation. The person must be paid fair market value for the property that is taken. Amendment 6 says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So you're entitled to a speedy trial. Justice cannot be unduly delayed. In the federal courts, the general rule is that a prosecutor must start the trial no more than 100 days after the arrest. If you were allowed to languish in prison for indefinitely, they could arrest you, accuse you of a crime, but never give you a trial, thereby, in effect, punishing you without convicting you. You also are entitled to a public trial, so the trial cannot be held in secret. You have a right to an impartial jury, a jury of your peers. You have the right to be informed of the accusations of the crime that you've committed. Witnesses can be compelled to testify or hand over relevant materials. So if you know there's a witness who can testify that you're innocent of the charges against you, you can force that witness to come and testify in court on your behalf. You have the right to confront witnesses against you. That means they have to give their testimony in court, where you can cross-examine them. And you have the right to counsel. That means the right to an attorney, even if you cannot afford one. Amendment 7, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Here, one of the most important aspects of this Seventh Amendment is that no fact tried by a jury shall be otherwise re-examined in any court. In other words, jury verdicts cannot be overturned with regards to facts, cannot be overturned later by another court or by a judge. If you are accused of robbing someone and the jury determines that as a matter of fact you did not do so, then the jury's word is final on that point. This is just an extra example of how important the Founding Fathers considered trial by jury. Trial by jury is mentioned 3 times in the Bill of Rights. Thomas Jefferson wrote, "I consider trial by jury as the only anchor ever yet imagined by man, by which a government can be held to the principles of its Constitution." Amendment 8 says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So you are protected against excessive bail, excessive fines, and cruel and unusual punishments. The interesting thing about Amendment 8 is that 3 of these words are very subjective. Excessive, cruel, and unusual have meanings that can vary over time and according to different people. What is excessive, what is cruel, and what is unusual. This is especially controversial perhaps with the death penalty. And in Gregg versus Georgia in 1976, the Supreme Court ruled that the death penalty is not a cruel and unusual punishment. Amendment 9 says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So there are unenumerated rights. There are rights that you have that are not specifically mentioned in the Constitution. The trouble is how to determine what these rights are, since they're not mentioned by word in the Constitution. Some people, for example, believe that privacy, although the word is not mentioned in the Constitution, privacy is an example of an unenumerated right that all individuals possess. In one case, Griswold Griswold versus Connecticut from 1965, the Supreme Court ruled that the First, Third, Fourth, and Ninth Amendments, taken together, create a zone of privacy. Amendment 10 says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. This means simply that the Constitution does not create an unlimited federal government. It is limited to the powers that are delegated to it. Anything not delegated to it in the Constitution is assumed to be a power that states retain for themselves.